me, the just and equitable remedy is for the appeal to be decided on its merits by the court that ought to have decided it. More importantly, in the main, but remain for determination in the appeal are factual questions that do not ordinarily fall for determination by this court. The jurisdiction of the court is confined to constitutional issues and arguable points of law of general public importance, which ought to be considered by it. In this judgment, we dealt with factual issues, but crucially, without deciding them, purely to demonstrate the Supreme Court of Appeal's failure to comply with the duty of proper consideration. We cannot suddenly be at large, as the legal language says, to determine those factual issues. The matter must be remitted to the Supreme Court of Appeal for a proper determination of the appeal, and that must be before a differently constituted panel of the Supreme Court of Appeal. The court makes the following order. 1, leave to appeal is granted. 2, the appeal is upheld. 3, the order of the Supreme Court of Appeal is set aside. 4, the matter is remitted to the Supreme Court of Appeal to be reheard by a differently constituted panel of judges of that court. 5, each party must pay their own wasted costs in respect of the abortive hearing of the matter in the Supreme Court of Appeal. 6, the first respondent must pay the applicant's costs in this court, including the costs of counsel. I hand down the judgment.
Not what we're expecting today. How do you feel with the people going back to the Supreme Court of Appeal?
No, obviously, we expected a different decision, and we have to abide with the court decision. And we're going back to the SCA because they have said that the SCA must apply themselves properly. And maybe outline the reasons that they should lead them to a decision. That's what we're going to do.
Do you feel that you could...
We'll go to the SCA, and the SCA must just relook at the case and then provide us with the judgment that will then stand the test.
Yeah, the court talk about the shortcomings of the ruling from the SCA. What do you make of that?
Well, the court has not decided on anything that the SCA has done except for them not to express themselves on certain things that were before the SCA. Listen to what Justice Madlanga was saying that in terms of especially the determination of the CEO, they did not, I guess, thoroughly deal with that and why it was inequitable. And I think the High Court did that. So, yeah.
Do you remain confident that you'll be able to convince the SCA that you are entitled to the over 9 million rand that you've lived?
No, definitely. It's our case. We'll also address the issue of the cross appeal, which they want us to do, and we'll do that.
Yeah, but the legal costs fighting this battle continuously are enormous. The average litigant would not be able to do what you.
Yeah, but I know, but we'll do what we have to do. Yeah. Are we fine? Thank you.
So tell us how you feel about the outcome of the Concord case today.
No, look, we are disappointed about the outcome of the court case. The Constitutional Court has been used as an appeals court. Our belief is that the SCA is more versed in civil litigation compared to the Constitutional Court. I don't see any constitutionality difficulty that was in this thing, but basically we are disappointed.
Thank you very much.